Hello and welcome to another special all live edition here at the whatever the heck this is, the Tom Grieve channel. We appreciate you joining me for covering two breaking Supreme Court decisions here. Two cases. First case, Maryland shall issue. This is a case dealing with Maryland's handgun purchase license restrictions. So if you want to purchase a firearm in Maryland, you have to be specifically a handgun in Maryland. You have to be 21 years of age or older. You have to be a Maryland resident. You have to go through a 4-hour firearm training course, a background check, submit fingerprints, as well as a $50 fee. There's all sorts of specific things that particular firearm course has to cover as well. The license must issue within 30 days, and if you get it, you can then purchase handguns. It's valid for 10 years. There's a $20 renewal where I think you do not need to redo the classes and resubmit fingerprints and all that kind of stuff. You also, of course, have to pass a background check. This was appealed to the United States Supreme Court on certiorari, and the answer was no. The Supreme Court will not be taking this case. That is, frankly, not good. It's not a crisis, and I'm going to be explaining why, but let's be very clear. I do not like this. I want the Supreme Court to smack this down, but let me get through the second case, and then I'm going to start to kind of put together the whole picture. Right now, I'm just explaining the chess pieces. Then we're going to start moving them around, start playing some chess. So Maryland, the shall issue case, that has been denied by the United States Supreme Court. So that's the end of the road for that. The second case that also has the end of the road. So in other words, Maryland wound up winning. The Second Amendment lost as a result. Same deal here. We're talking about Gray versus Jennings. We are in Delaware. We're talking about their version of the so-called assault weapons ban, as well as the large, i.e. normal capacity magazine ban. The interesting thing about this, when the United States Supreme Court denied this petition as well to save the Second Amendment, is that if you actually go back and if you read the circuit court, so remember, because I realize that this is confusing for those of you who have a life and aren't like me, just kind of reading all these decisions all the time. Federal trial courts, there's about 94 federal district courts. That's where most cases, most lawsuits originate from when we're talking about challenging Second Amendment laws, things like this. From there, from federal trial district courts, we go up to about a dozen, depending on how you want to count them. There's 12 or 13 federal circuit courts of appeal. From there, we go to the United States Supreme Court. So we're talking about two cases that went from district court all the way up to circuit court, and now they got shot down going up to the U.S. Supreme Court. Gray versus Jennings, though, wasn't shot down on the basis of the fact that the United States Supreme Court does not want to hear a so-called assault weapons ban or magazine ban case. I'm going to explain why, because if you actually look at the court order, I'll get that up after this is open, but at the end of the day, the United States Supreme Court, when they deny certiorari on cases, they usually don't explain why. It literally just goes on a lengthy list of no's. And that's what we have it on here. I think on page 4, the PDF was you could find both the cases. First Gray, and about 5 or 6 later, you then have the Maryland shall issue cases being rejected, not having granted certiorari. Occasionally, very occasionally, the justices will actually grant, or the dissenting judges, in other words, the judges who want to have heard the case, will actually put in essence, a dissent and something that represents more or less an opinion going into why they believe the case should have been heard or why they're turning it down right now. Oftentimes it's because the case had some jurisdictional defects. Sometimes it has to do with the fact that maybe it just procedurally was not on the right footing. So oftentimes when these cases go to the U.S. Supreme Court, and this is important to understand, it's not that the justices don't believe that the issues have merit. Rather, the case itself may have come to the United States Supreme Court too early. So the justices, they want a final ruling from that federal district court because maybe it was appealed pretty early. If you imagine a baseball game, 9 innings, maybe one of the teams didn't like a ruling in the second inning of the game. Great. So they appealed it up and they appealed it up, and now we're at the U.S. Supreme Court. And the U.S. Supreme Court says, you know what, guys, finish your game, get to your 9 innings in. If you need overtime, take it. But we're not going to deal with this until we have the full record, until we have all the facts, because courts of review, circuit courts, the United States Supreme Court, these are rarely, if ever, a court of fact. In other words, they're dealing with law. They are not there to develop facts of cases. There's a couple of very obscure exceptions, but generally speaking, they are not there to develop facts. So they want the facts to all come out onto the record at the district court level, at the trial court level, and then, and only then, in many cases, they will then step in and intervene. Okay, so if both both Gray versus Jennings, as well as the Maryland shell issue case, are just on this blanket, we're not going to take it, then why do I think the US Supreme Court might actually be caring a lot about assault weapon bans and magazine bans? Well, the answer to that has to do with what cases they did not speak about. They did not speak about two very important cases. Snope v. Brown, another Maryland case, this one explicitly dealing with the AR-15 ban, so-called assault weapon bans, as opposed to the Maryland shell issue, which is dealing with this encumbrance on the Second Amendment of if you have the audacity of wanting to purchase a handgun. Okay, so these are two separate cases. Snope v. Brown coming from Maryland, but we're only dealing with AR-15 and assault weapons ban, as opposed to Maryland shell issue. This is the license that you have to get if you want to purchase handguns. The license to purchase handguns one got kicked back. And I'm not done moving the pieces around. I'm just putting them on the board still. We've got two more parts here. So Snope v. Brown is going to be getting relisted. They haven't published it yet, but it's going to wind up getting relisted. And then also a second one, Ocean State Tactical, which is the explicit magazine ban coming out of Rhode Island. These two cases, the Supreme Court did not talk about. All right, so we've got some facts on the table. We've got some chess pieces on the board. Let's start moving them. The reason why I think that this is going to be a net good, despite the fact that if it were me on the Supreme Court, we would be hearing virtually every single Second Amendment case that we can possibly get our hands on, is the fact that, frankly speaking, the Supreme Court cannot do that. They simply lack the bandwidth. There's well over 5,000 petitions that are sent to them in every year, sometimes 7,500 or more. The acceptance rate across the board is usually between about 2 to 3%. Keep in mind, there's a lot of interests that justices want to be ruling on, they want to be taking a look at, just like we're talking about things that we know are crucial to the republic and to liberty within the Second Amendment. There are people who don't know the first thing about a magazine versus a clip versus a whatever, who would be just as passionate about something we couldn't even pronounce. Okay. So there are other things that are going to keep bubbling up elsewhere. That does not mean that the licensing issue is dead. So it does not mean that, hey, therefore, now the government can just impose whatever licensing regime it wants on purchasing handguns and purchasing any kind of firearm, and we're just stuck with it. It just means that for right now, the court is silent on that topic. That's it. At least that's what I hope it means. They have to keep the bandwidth open for what they think are going to be more important cases. If they wind up shooting down Snope v. Brown, if they wind up shooting down hearing Ocean State Tactical, so if they don't want to hear an AR-15 ban case, if they don't want to hear a magazine ban case, and again, that other Delaware case, Gray v. Jennings, that case was bogged down and mired in procedural issues. So even though it was a Second Amendment case, that was a case that really revolved heavily around an axis, not of the Second Amendment, but about procedural issues dealing with injunctions and when can you issue a preliminary injunction and or a permanent injunction for that matter, and on what basis should that be done and all that kind of stuff. So it's a Second Amendment case, but the exact specific stance of how it was being appealed was really much less on Second Amendment grounds. If they wind up shooting down these other two, Snope v. Brown and Ocean State Tactical, then I'm going to have much more concerns about, wait a second, what's going on here? But the fact that those have been relisted suggests to me that this is hopefully going to be an issue of trying to keep the door open because they only have a couple more seats at the table. And they can always revisit the licensing issue down the road. They can always revisit these procedural issues down the road. But when they only have a very finite amount of seats at the table, they want to fill it with the most important people that they can get there, the biggest issues that they can seat. And I think that's what is going on here. So look for that to happen, hopefully in the next few weeks when we start getting these decisions about whether or not they're going to be granting certiorari on these cases. It's also starting to get a little bit late in the term. The Supreme Court kind of has a season to it. So we're starting it a little bit later on in the season, so to speak, for the 24-25. So the 24-25 season began, I think, back on October 7th off the top of my head. So it's going to be pushing through early October this year in essence. So there could also be questions of, again, they want to hear these issues, but maybe they just want to do it in another term as well, in kind of the next season. And for those of you who are wondering what the heck's going on with the relist, what are these conferences? This deals with how the Supreme Court decides to take cases. In a nutshell, and we know this because Chief Justice Rehnquist, the late Justice Rehnquist, explained this process in his book called The Supreme Court, which was published about 25 years ago now, I think about the year 2001. And he explained how this all works. In brief, promise this is short. It's kind of interesting. So the Chief Justice will distribute at all these different conferences where the justices will meet to talk about what cases they're going to take. And the Chief Justice will start off by saying, here's a list of cases on my discuss list of what we're going to be going through. And then the Associate Justices, which is code for everyone not named the Chief, will then go ahead and they'll add cases on that list. So that's the gist to it. The great majority of petitions, however, never even make it to the discuss list. And as a result, they're basically denied out of hand. And then they go ahead and then they'll wind up going through and talking through and voting about whether or not they're going to be taking these cases. Sometimes they wind up pushing them back over. Okay. So there's been a lot of big Supreme Court cases for the Second Amendment, like Heller, which was relisted twice, McDonald versus City of Chicago. They took that in the first one. Catano, dealing with common use, dealing with the fact that, hey, something did not have to be in existence back in 1791, Second Amendment adoption, in order for it to be protected today, 10 times. Brune was distributed for conference 4 times. NRA versus Vullo, a little bit more of a First Amendment case, but just the same, 5 times. Rahimi, twice. Garland versus Cargill, that was 4 times. That's the case that deals with whether or not a bump stock device is a so-called machine gun as defined by statute, dealing with the ATF rulemaking. Garland versus Vanderstock, twice. That's the so-called ghost gun privately manufactured firearms issue. So just because something gets distributed multiple times, that is 0%. For those of you who are 80s movies fans, that is not a game over man situation. All right. It is not that. Now, oftentimes the deeper it goes in the relistings, that's not necessarily the world's best sign, but at the end of the day, it's not over till it's over. So we'll be obviously staying on top of all of this. We've been covering those cases previously back in the lineage of this channel. Obviously, don't want to have spending 20 minutes to go through all that today. We're going to get to our quote of the day. First, be sure to hit that like button if you've not already done so. Helps us out. Also, I know that this is going live, so there's probably some people chatting that up. I will do my best to read those chats afterwards. The best way to get my attention is after this video is done going live. Of course, you then get the general YouTube comment field. Post up your questions there. I'm thinking about doing an AMA, so an Ask Me Anything video. I haven't done those. I haven't done one of them. I'm looking at Derek off camera here. I think we haven't done one of those in about a year or something like that. So if you're interested in that, post up some questions and some comments on this. I'll be sure to go through those. If we get enough interesting ones, we'll catalog those through all together. And now let's close with our ever popular quote of the day. This one comes from Greek thinker philosopher Aristotle, who once said, quote, "Misfortune shows those who are not really friends." That Aristotle, he was really onto something, wasn't he? We appreciate you sticking around. I appreciate you sticking around. And as always, I will see you in the next one.